When I'm working with elders, a lot of times I'm actually working with their agents under the durable power of attorney, because the elder that is my client has already lost capacity. They're already suffering from dementia or Alzheimer's at a level where I wouldn't be able to converse with them directly. So from my position as an elder law attorney, really the most important document I see necessary is the durable power of attorney. And in October 1st, 2011, our statute in Florida was revised substantially. So in the past, where you may have seen a 2-page durable power of attorney, now we have a 20-page durable power of attorney. So they implemented what are called superpowers, and those are powers that have to be initialed to be valid. And why do I mention that? I am still in 2017 seeing durable powers of attorney come across my desk, some even done by attorneys that don't follow the law change. So if the person lacks capacity by the time the agent comes to me and the superpowers weren't initialed, many times we have to go to court to get those powers. So I'm going to explain one of the powers that's very important for future planning. If your income, your gross monthly income exceeds $2,205 a month, which isn't enough to pay for a nursing home, you technically do not qualify for Medicaid without establishing what's called a qualified income trust. So the qualified income trust is also known as a QIT or a QIT. It's also sometimes referred to as a Miller Trust. That QIT is what will allow you to qualify for Medicaid, but if your durable power of attorney doesn't have that initialed superpower and it was done after October 1st, 2011, the agent cannot establish the QIT. So what does that mean? If there's a spouse, the spouse can sign the QIT. But if there's no spouse and the person lacks capacity, I have to go to court and I have to ask the court to establish the QIT for the sole purpose of qualifying for Medicaid. I can do that, but the cost goes up substantially because I have to file a petition, we have to have a hearing. So these are things that a lot of times I see people that say, I don't want to pay an attorney, and I'm going to just get my DPOA from Office Depot, or I'm going to download it from LegalZoom. And although that may be better than nothing, usually by the time they get to me, the person lacks capacity, and those kind of durable power of attorneys are insufficient. So they're very unhappy when I tell them it's not sufficient. So durable power of attorney withstands incapacity. So even if the person lacks capacity, that document's valid. And why it's so important is most of us have assets only in our name. Even if you're married, you may have an IRA only in your name or some account only in your name. If you lose capacity, no one can access that account without a durable power of attorney. So even if I were in a car accident and I was in a coma, my husband would not be able to access my IRA without a durable power of attorney. So it's very, very important. It's a very powerful document, so you want to be sure that you absolutely trust the person you're naming, because it's valid the moment it's executed, and unfortunately in Florida we see people with durable power of attorney steal money. What happens if that occurred? We file for guardianship if that occurs so that we stop the theft, and then we try to take back the money. But why I say that is a lot of people say, well, I don't know who to name, and I don't trust my oldest son, can I name my second son? Of course. You want to name the son or daughter you trust or the family member you trust. I normally don't recommend naming neighbors or caregivers because that's where we see a lot of exploitation. And unfortunately, in our judicial system, it's very hard to get the state attorney to prosecute those because it's such a high burden of proof that the person lacked capacity and it wasn't truly a gift. So durable power of attorney is very important. It may also have your healthcare surrogate language in it. I separate mine. I make a separate durable power of attorney and a separate healthcare surrogate because I do a lot of guardianship. And when you file for guardianship, oftentimes the durable power of attorney is suspended. So I don't want to have to argue whether the healthcare surrogate language is suspended or not. I do a separate document. It's not incorrect if they're combined, but many times you want to name someone else to make your healthcare decisions. So a lot of times in families, we have one child that's good financially, and then we have another child that maybe is a nurse or is going to be more compassionate or understanding of the medical. You can name different people, and you can name successors. You can also name co-agents. So not my favorite situation. I don't like naming co-agents because if there's a conflict, there's no one to solve that conflict except the court. And I've been in front of the judge to solve conflicts between co-agents. So I usually recommend you name one person with a successor and then have a third successor. So if someone can't act or they predecease you, we have someone named to act. The healthcare surrogate is the one that makes medical decisions. They would be able to make those decisions if you wanted, even while you have capacity. But normally that does not come into effect until you lack capacity, because most people want to make all their healthcare decisions while they're able.